Thank you. I'm delighted to be here to discuss issues that I think are vitally important and especially important to hear and to discuss here in the Bay Area. Let me explain a little bit of the background why I think it's so important. I'm a litigator. I handle disputes, try cases, generally involving the introduction of new technologies or the operation of businesses that depend on technology or provide online platform services to the public. I tend to represent the insurgents or the entrepreneurs defending their technology and their business models when they get challenged. And over the years, I've seen that these battles are never ending, and they are hard fought. They are very, very high stakes. And over the years, as I've handled more cases involving big issues and challenges, I've seen that if a lawyer stays on top of every case that comes out the day it comes out, that lawyer is behind the curve. If the lawyer stays abreast of new legislation that's working through committee or might be passing in one chamber of Congress, that lawyer is maybe 2 years behind. A lot of what companies and individuals are going to face as the pressing legal issues of the day 4 years from now and longer are being debated today in policy forums in Geneva, in Brussels, in Paris, in Washington. And my clients count on me not just to handle their litigations, not just to handle the disputes that have matured, but to help advise them on how to construct a business model, how to frame a new technology to be both accepted in the marketplace and a survivor of the legal challenges that are inevitable. And years ago, when I started practicing in Silicon Valley, it was almost a given that a company that was facing a litigation risk would not get funded, and venture capitalists would shy away. Part of the stakes there is that not only might they lose their investment, but in some high-profile copyright cases, for example, against Napster, the plaintiffs would sue the executives individually and try to hold them personally responsible for liabilities. And a lot of companies are growing up in uncertain areas of business and legal risk. And so it became very, very important to try to figure out where is the law going in the next 2 to 4 years? How does one help shape the development of the law and of public discourse around the issues that then translate into legal and legislative and policy initiatives? So as a consequence of that, going back 5 or 10 years, I started trying to pay attention to where these policies may develop. And I started going to a number of the forums, whether it was from a business perspective, because that's how I would go as a member of the business community. I would go to the U.S. Council for International Business, or the International Chamber of Commerce, or the Organization for Economic Cooperation and Development in Paris, or to the World Intellectual Property Organization, or the WTO in Geneva, and the like. I'm not competent to get into the fray in the European Union, so I tend not to go to Brussels, but I'm certainly aware of the risks there. So I've learned to see just how the policies that get debated originally in things like little white papers or commissioned reports, and then become committee papers and reports, then become policy statements by various organizations, then become briefs that government agencies or government representatives have. I've seen how they end up years down the road playing out in the day-to-day activities of businesses and, frankly, in the lives of people who are trying to get those businesses off the ground. So for me, the policy world and the practical day-to-day, will my client survive questions, are tied together very forcefully. Now, one thing that's been frustrating for me out here in the Bay Area is that when I talk to people about what's going on in Brussels or in Geneva or in Paris or what have you, people say, no, I just deal with technology. I don't deal with that other stuff. And I think the world has changed in the last number of years, but I know that probably 5 years ago, people in California and in the Bay Area had a real aversion to getting involved in policy debates. And part of it is because they were pretty arrogant. And they would say, well, we don't have to worry about that because the policy debates at the end of the day are irrelevant because I'm going to build a better mousetrap and the world will beat a path to my better mousetrap. Well, I think they've learned that the federal government can outlaw that mousetrap or can outlaw the particular design choices of that mousetrap, or the government can shift incentives and restrictions and impose obligations that might cause the entire engineering team on that mousetrap to walk off the job. I've had a client with its engineering team walk off the job of a project because it was scared of being sued for developing the project. So I think that we see today more wisdom and less arrogance on this subject. But what I sadly don't see enough of is sort of internet citizens stepping forward, entrepreneurs or those who represent entrepreneurs stepping forward to make sure that their voices get heard. Google's voices get heard, Facebook's voices get heard, Amazon's voices get heard, Intel's voices get heard in Washington. And they're important, and they often, to their credit, speak in a way that does respect a lot of public sentiment, in a way that aligns with public interest on a large number of topics. But it's not enough to sit back and let the big companies speak for these interests. And so I'm hoping that we'll have more involvement and engagement by persons out here, especially by members of the Internet Society or other similar groups, to take an active role and to help in participating in events like IGF USA or IGF and other events so that your voices and the voices of a myriad of different diverse interests out here get heard. So I want to talk about, let me see, I have just one slide. This is all you're going to get today. Why is this not? Maybe I have to use this. Maybe I'll do it the old-fashioned way. Page down. That's not even working. Let me click here on next. There we go. So these are the topics I'm going to cover today. It's just one slide, so you can see what's coming up. And I'm going to speak for a while, but this is not meant to be a lecture. It's meant to be an invitation to discuss observations and perspectives that I've gained engaging in the battles I've engaged in. And I hope that, at least to some degree, you'll pop up with questions or observations so that we can work through this together. I'm not going to just speak for a while and then open it to questions at the end. I'm happy to talk together. I want to talk first, though, about the rule of law. Because, well, I'm a lawyer, it sort of comes naturally to me, but it is also extremely important in the fights that I have been fighting, both in the courtroom and at the policy level. And I want to take you back to a panel that I shared, about 6 or 8 years ago, I think, with the general counsel, the then general counsel of NBC Universal. Now, to set the stage, you have to understand that a lot of the time I have been opposite the entertainment industry. I like to joke that my career consists of essentially defending the internet and defending technology against Hollywood and the federal government. That included, for example, defended the case that legalized MP3 players. My client happened to come out with the first MP3 player. How many people remember the Rio MP3 player? How many songs did that MP3 player hold? A whopping 12 songs. Okay? And when it came out, the recording industry tried to ban it as an illegal piracy contraband device. And thank God we won that case. And the judge originally stopped it and held it off the market for 10 days. And we came back on the next hearing and we won, and the judge then allowed it, and we won that on appeal. But the recording industry was trying to shut that down. Another one of my favorite cases was I defended Google search against a copyright lawsuit that said Google search is just a big copyright infringement and is illegal and needs to be hamstrung because it's allowing people to find things on the internet that may be infringements. And Google search shouldn't let people find infringements on the internet. And Google is responsible if people can use Google search to find infringements on the internet. So I defended that case, and that established that Google search was fair use. And it established that mere linking on the internet is not a copyright infringement, and a few other things. On the governmental front, one of my clients had a domain name, had a hip-hop blog website where he broke news about hip-hop artists and about new music. He got a number of items from record labels themselves and from artists and producers and the like. And my client woke up one day and found that his website had been taken over, and in place of his website on the page was the seal of the FBI, the Justice Department, the Department of Homeland Security, because it had seized his domain name on a seizure warrant out of New York that alleged that his blog had linked to 4 infringing songs. And it took a year to get it back from the federal government. And during that time, the federal government had gotten extension after extension of, well, when it seized the domain, I filed a demand for the return of the domain, which is the way the law works. And that gave the government, I think it was 60 or 90 days, to file a lawsuit for forfeiture of the domain for alleged violations. And the time came and went for the government to act, and nothing happened. I called the government lawyer and said, well, looks like you didn't file a forfeiture and give us the domain back. And he said, well, not so fast. I said, why not? He said, we got an extension. So I'm opposing counsel. This is a little weird. Why didn't I hear about it? You didn't hear about it because it's secret. I said, really? Okay. Well, can you just redact the sensitive parts of the extension order or your motion and send me that? We don't do that. May I ask to be informed if you seek a further extension? No. Well, if you seek a further extension, will you tell the judge and that I oppose it and want an opportunity to be heard? I note your request. 60-day extension came and went, nothing happened. I called the lawyer. So what's going on? He said, got another extension. I said, did you tell the judge what I asked you to tell the judge? He said, I'm not telling you what I told the judge. That's secret. And I said, are you telling me that the reasons for the extension of all this time are secret, or the fact of the extension is secret? He said, oh, the fact of the extension is secret. I said, didn't you just break the law by telling me then? Long pause. This went on for 180 days of secret extensions where I was not allowed to see anything. I was not allowed to know any reasons for anything. And then I get an email one day saying, on further reflection, the government has decided not to seek forfeiture and will be returning your client's domain in due course. Hey, big victory. He was only knocked off the web for a full year before the government gave it back, having never filed the lawsuit it needed to file to justify why it had seized the domain. Well, so the Electronic Frontier Foundation, the California First Amendment Coalition, and Wired Magazine came to the rescue. They filed a motion with that court to unseal all the secret papers. And the government, to its credit, did not oppose the motion. And so the day came when I got my hands on the super secret filings. Now, what national security reason do you think there was for the secrecy? The filings said, Your Honor, we need more time to file our forfeiture complaint because we don't know what the facts are to put in it, and we're waiting for the Recording Industry Association of America to tell us what they are. And the second extension was, well, they still haven't told us what the facts are, so can you give us another 60 days? And the third extension was, they still haven't told us what the facts are. They promised us a report in 30 days. Please give us 60 more days. Well, it never got filed. Okay. So that was sort of one thing that has sort of caused me to look at what's going on in the relationship between government enforcement and intermediaries with technology providers and the government's relationship to technology itself and Hollywood's relationship to technology. So I want to come back. I was telling you that I was on a panel with the general counsel, then general counsel of NBC Universal. And he got up and he was castigating the internet as a lawless place. It was the Wild West. And he said, we need to bring the rule of law to the internet. But he had an unusual suggestion for doing that. He said, and we bring the rule of law to the internet by implementing it in silicon and in code. Now, his version of the rule of law and my view of the rule of law were very different. Because I think of the rule of law as a system of rules that govern public behavior, that govern actions. And he was seeing the rule of law as restricting technology and restricting capability. So if we take it out of the highly charged copyright context, let's put it onto things like automobiles. And I drive up 280 coming to work every morning. And there are a bunch of cars that are a blur as they go past me. It made me stop and think about Ferrari and the rule of law. Because I got to tell you, I do not know anybody who buys a Ferrari with a purpose of always staying within the speed limit. So how do we judge Ferrari in relationship to the rule of law? Do we make Ferrari responsible for speeding by its owners? Do we cause Ferrari to adjust its vehicles never to be able to speed? Do we require Ferrari to report to the California Highway Patrol when somebody speeds? No. We make people responsible, and we devise ways of holding people accountable. Now, I've got to tell you, it's fascinating. In Europe, places I've been lately, nobody speeds. You know why? Because the government has its own technology solution. Sorry? Speed cameras. Okay, so the government has one. And you're not dependent on whether you happen to be the person that highway patrolman caught. They're basically catching everybody. But here you sort of take your chances. There are different ways of solving these issues, but we've certainly, on many, many types of legal regulations, imposed the rule of law at the level of behavior and not capability. Yes?
Yeah, I've got a question. And I think I've mentioned this to you before. With self-driving cars, how do you expect the rule of law to be implemented then?
That is a very difficult issue because that's going to get into artificial intelligence a great deal. I think that, number one, owners under the traffic code and the criminal law, owners are likely still to be liable for them. But when they engage in Buggy behavior, that's right. Well, it's a little bit like what happens when the walkway between the two wings of the hotel collapses, okay? And 16 people get killed because they've fallen 4 stories. There are traditional product liability type rules that come to bear on it. But that would tend to be a little bit more in the allocating the risk after the fact than necessarily in terms of restricting behavior beforehand. Now, it may well be, for political reasons, subject to particular rules that say, for example, do we want the government saying to Tesla, your car may never go to the left of a yellow line? I'm not sure we want the government saying that to Tesla, because in most instances that should be correct. But when when a tree is down on one side of the road and you've got to go to the other side of the road, how's the Tesla going to do it? You don't want to have 16 Tesla owners, calling for the manual override. Anyway, a lot of the focus I see is that there really is a war on where do we apply the rule of law. There are those who want that application of the rule of law to be on the technology and to make the technology providers either implement, design solutions to the legal problem, or make them liable for wrongful conduct using the technology. Now, what is the most dangerous technology in the United States for which the technology providers are never held liable? Guns. Okay. And okay, I get it. There is a Second Amendment right to bear arms, and whatever you want to think about the controversies over the preamble to the Second Amendment or other things, yeah, there's sort of a constitutional right to bear guns. But that wouldn't be inconsistent with a decision to impose liability on guns. And when it comes to the technology world that we are living in mostly, and online platforms, the exciting new developments are communication technologies. And communication technologies themselves present First Amendment interests. Now, I'd like to say a little bit about First Amendment interests, because I got to tell you, I went to Syria in July 2010. It was 7 months before Syria blew apart. And I've sort of learned a lot by watching what has happened there since then, and also understanding what Syria was then before it blew apart. But it was notable to me that when I was in Syria, I could not access YouTube, Twitter, Facebook, Skype on my computer, but I think I could do it Skype by phone. I could not access the social network platforms in Syria. And it got me thinking at the time, what was the threat to the regime? What was the threat? And it made me stop and think that it wasn't necessarily speech. It was connections. It was people being able to reach each other. What was the landmark event of the Arab Spring? I think it was Tahrir Square. People coming together in Cairo to demonstrate that they were united against the regime in Egypt at the time. I came to see from my experience in Syria that the communications technologies fundamentally empower a freedom of association, a freedom of virtual assembly that was essential. And it made me stop and realize that the freedom of assembly and freedom of association are actually more fundamental than freedom of speech. Because free speech does you no good when you're in solitary confinement. You can talk to the walls all you want, and nobody's going to limit your free speech. But when people get in the way of your communicating with others, of your assembling in a virtual manner, or associating with others, reaching others, that is fundamental. And if you think about it, I won't go into it now because it's another talk, but I almost think of the freedom of this ability to connect as at the core of all of the First Amendment. It's at the core of freedom of worship. Early Christian communities were gatherings in private houses. Muslim concept of Jummah requires a congregational, multiple worship in the presence of other people. So, freedom of religion, nobody can pretty much regulate your private thoughts, but they can regulate your public observance, and that has a lot to do with communication. And freedom of speech, freedom of the press really depend on reaching people. So those are the things that are at issue here. And that's why I like to say that technology and online platforms are controversial because they are important tools for the public. And what the public does is, in many instances, controversial. And I'll just touch upon this briefly. I think it was the Bernstein case, the Electronic Frontier Foundation established that computer code is protected as expression. It's protected as free speech. And that was an important landmark for establishing that design is itself a form of speech and expression that has its own inherent expressive value and expressive importance in our society. Now, there are a number of areas, you may find it surprising, maybe not, where certain designs are inherently illegal. Do you know that it is illegal to develop a digital audio tape recorder that can record from a digital audio tape that itself is a copy of some other original? It's illegal to do that. When Sony came out with digital audio tape recorders in 1992, the recording industry went to Congress and said, this is intolerable. Digital copies are perfect reproductions. And in the analog world, we put up with people copying and copying analog tapes because there was a degradation with every generation. But with this new digital world, it is intolerable because 1,000 generations of reproductions can be made with no deterioration. Congress, you must put a stop to it. And there was a lawsuit pending by songwriters against Sony for introducing the digital audio tape recorder. And that lawsuit was settled by this sort of compromise of going to Congress and saying, okay, Congress is going to regulate this. And if you devise a digital audio tape recorder that will record from a CD that's maybe a copied CD or reproduced CD, maybe with MP3s on it instead of a Red Book CD that you bought through Amazon or whatever, you could be liable for $2,500 per unit that you make. It is an absolute design restriction. It is against the law and may even be criminal if you provide people with, and most of you probably know something about this, if you provide people with software that will allow you to reproduce movies from your DVDs onto your computer. It's just flat out illegal to provide that. And there's a similar provision that makes it illegal for somebody to bypass encryption in order to access a copyrighted work. That's how you get prosecuted if you watch, let's say, a pay-per-view boxing match by having a hacked access to the satellite feed. But if you provide somebody tools to break encryption, even if their purpose in breaking encryption, even if they provide, even if the purpose for the encryption, even if the purpose for the encryption is entirely legal, then because it's fair use or what have you, it's still flat out illegal to provide the technology. And we see right now debates in Congress as to whether it should be illegal for Apple or Samsung to make cell phones without putting a back door in them. That's our current debate. And so are there going to be harsh penalties over design choices? So this is very, very active right now. And these are some free expression interests. How somebody chooses to design a product is a form of free expression.
What do you mean by the backdoor?
A backdoor means that it'll allow the government to get in and find out what's on somebody's phone, even though the phone is otherwise encrypted and otherwise secret. So, your kids, your neighbors, they couldn't find out what was on your phone, but it would be like your TSA lock on your luggage. Okay? Every lock on your luggage, unless you want it broken off, has to be available for TSA to unlock with their special key. And it would be the same sort of thing for your computer, possibly, or for your phone, or what have you.
That's true now?
It's not true yet, but it is. And to a certain extent, the government tried to argue, without new statutes, that in the San Bernardino iPhone case, the murderers in San Bernardino, the government wanted to force Apple to develop software that would hack into its phone. Now, the problem is you can't just develop software that's going to hack into Joe's phone without giving a path into everybody else's phones. So this is a huge issue right now. But then also, apart from the free expression interests of the designers, there's a public expression interest. And one reason why that technology and online platform providers are in the hot seat is that they are the choke point for public conduct, public behavior. Because they are in everybody's pocket or on everybody's desk, behavior that goes through those systems or through the services can be regulated, and if there are important governmental or social purposes to be served, the government or private interests bringing lawsuits will try to force a form of control over that public expression by the technology providers or by the platform providers. This leads to technology or platform providers being deputies for government enforcement. And we see this, this absolutely happened with WikiLeaks in the early days. WikiLeaks in the early days allowed people to make financial contributions by charging their contributions to their credit cards. And the government went to the credit card companies and said, if you know what's good for you, you're going to cut WikiLeaks off. Did the government bring a lawsuit holding that the payment processors had an obligation to do so? No. But it was a sort of a, if you know what's good for you, you're going to do this. And so they did what the government bid in enforcement against WikiLeaks. There are, and technology and platform providers aren't just deputies for governmental enforcement, they're also deputies in certain instances for private enforcement. I'm very sensitive about the case involving the credit card processors with WikiLeaks, because I defended the credit card processors when they resisted a lawsuit by copyright holders who said in their lawsuit that the payment processors and banks should be liable for statutory damages of millions or billions of dollars for failing to cut off the processing of payments for merchants who were alleged to be copyright infringers. And there was a high stakes case. Somebody writes in to the credit card company and says, gee, Avenue Video, on Telegraph Avenue in Berkeley is selling bootleg CDs, cut them off. And the response by MasterCard or Visa say, oh, wait, on what basis? if there's a court order that somebody stop providing a service, I get it. But this was a threat of millions or billions of dollars of liability for simply choosing not to get into that enforcement role and say, okay, you've told us that people are infringers, therefore we'll take your word at it and cut them off. We defended a hard-fought case, an ugly case last year, representing a major ISP on the East Coast, that its customers were receiving, it was receiving notices saying your customers are, we've identified this customer at this IP address as having engaged in copyright infringement of our songs through BitTorrent. And here's a notice that we want you to send to your customer. And the notice said, hey customer, your ISP has sent you this notice because you have been identified as having an account that's an infringing account. And unless you pay us $30, you're going to lose your internet service. And the ISP said, wait a second, we don't go in for that kind of stuff. We're not sending that stuff along. You take out that threat and demand, which to us feels extortionate. You take that out and we will forward the notices. And the company sending the notices said, no, we're not changing the notices. Now what wasn't as clear at the time is some people would get these notices and they would say, oh, this is ridiculous. But look, they're hassling me. I'm just going to go pay $30 and be done with it. So they would go to a website. There's in the notice, click here to resolve this. They go to the website and give their name, address, phone number, email, credit card number, pay the $30, and then soon thereafter they would get a letter or an email or a call saying, great, now about the other 200 infringements at $30 a piece, we think you owe us X and we're going to sue you or we're going to have your internet taken off, shut down. So this internet service provider said to the company sending these notices, no, you fix the notices up. We have a process for dealing with repeat infringers, but we are not going to process these notices. We will not forward them to our customers, nor will we take them into account in our process if this is the way you're going to do it. And the long and short of it is, they ended up sending the ISP 18 million notices. It overwhelmed the ISP's email server. The ISP said, this stuff is basically spam at this point. We cannot act on these. We've made it clear what's going on. And so they blocked them at the server level. And the enforcer was working for two music publishers. And the two music publishers ended up suing the ISP. And the main theory was that the ISP should be liable for failing to terminate people, failing to cut people off the internet. Because the rights holders in this case said, well, if you're not going to do this, if you're not going to go along with us on this, then you need to be cutting them off. And the ISP said, we have a process for suspending and several steps down the line, terminating people. But you're not part of that process because you wouldn't play with us. That case ended up going to a trial, and the ISP was hit with a $25 million verdict for failing to cut internet service to, I forgot what was the number, 55,000 people or something like that. And it's remarkable because today the Supreme Court came out with a very important decision. It was Packingham versus North Carolina. And that case involved a convicted sex offender. And in North Carolina, there was a law that said somebody who's been convicted of sex offenses may not access websites that may cater, in some respect, to children. And this guy went and posted to a social media site, of course, which children have access to, his comments about a traffic ticket he had gotten. and somebody in the state saw it, connected it to him as a sex offender, and he was prosecuted for accessing a social network for that purpose. And the Supreme Court struck that law down as an unconstitutional violation of his First Amendment rights, emphasizing the importance of access to social media and access to the internet by implication as a fundamental First Amendment right. So now you map that against the decision last year that this internet service provider was tagged for $25 million for failing to cut people off based on an allegation that the customers were infringers.
Are they appealing?
Yes, trust me. And I think the odds should be very good, but you don't know until you get the result. And you know, I'll leave that as it is. So anyway, question here.
How much do you attribute things like that $25 million verdict to perhaps judges or juries not really grasping the technology or the significance of it, and how much is like strictly legal like foundation?
Yeah, it's it's a combination of both of those, and it's also a combination of the fact that in everybody's sort of chest of drawers, there's some stuff that is not quite so innocuous seeming. And so in this case, I think people did not fully grasp that just because somebody's wireless network may have been used for an infringement doesn't mean that they did it. And you're not legally responsible for stuff that other people happen to do over your wireless. That's number one. Number two, it's not clear to what extent it's very clear that the jury was not allowed to know the full scope of the conduct of the enforcement company. For example, if you wanted to contest that $30 and you called a number to say, "Get off my back," the telephone script of the enforcer instructed these phone agents to say, well, if you want to contest it, you have to go down to the police department and file a police report, and they'll take your computer away for up to 5 days to inspect it. That's how and people faced with us say, pay $30. That kind of stuff was going on. Having said that, this ISP had an abuse department to deal with these things, who were pretty immature and said some pretty awful things about the process that frustrated them so very, very much. And the jury, I think, was inflamed by some of the internal discussions. But the jury was not allowed to know that the ISP explicitly was analyzing what the plaintiff did as extortion and said, we do not want to participate in extortion. So the defendant was not allowed to explain its rationale, and that makes sense. There are many grounds for appeal in this case, notwithstanding, not the least of which is that when it came time for the jury to be instructed, the trial judge in the case, there are 2 Supreme Court cases on with the standards, and he wouldn't use either of those Supreme Court standards to instruct the jury. So there's a lot there. But the main point I want to make is just the global point, that you're talking about a $25 million exposure for failing to terminate people's internet access. And that is saying that ISPs must be the gatekeepers of these issues, even when there is no specific proof to cut off any specific person.
Yeah, following on that, I think yesterday Google said they're going to police really hard for terrorism videos and stuff on YouTube. At what point does that violate, I think, Section 230 of the Communications Decency Act, the common carrier liability for user-posted content?
Yeah. Actually, no, it doesn't violate it all. It's expressly authorized by it. So the Communications Decency Act, Section 230, is a very, very important law, and it's under attack right now. But it has 2 sides, and a lot of people in the technology world focus on one side, but really 2 sides. it immunizes any user or provider of an interactive computer service where the liability would turn on treating that user or provider as a speaker. The law says a user or provider will not be treated as the speaker of information that originates with somebody else. So it's basically to say if you're the channel, you're not going to be liable. And there are a couple of exceptions for federal intellectual property and criminal matters. But there's another part of Communications Decency Act that also says, and you will not be liable for taking down what you choose to take down. And that's what would allow companies to decide what they want on their service or not. Now that sort of leads me into the hot button issues of online moderation, terrorism, hate speech, fake news, piracy, and fraud. How many people think that there is a clear definition of terrorism? Okay. How many? You do?
Yeah.
Okay. How do you define it?
Violence against, undiscriminatory violence for political purposes against civilians or anything else.
Okay. And how do you identify what is incitement to terrorism?
Oh, I don't know.
Rand Paul 3 years ago or so had a tweet saying, let's get clear, the Second Amendment is not about protecting your house against burglars, it's about using your guns to shoot tyrannical government persons.
I think incitement has to be immediate and specific.
Okay. And then how is Google going to know when something is immediate? And if it's immediate, maybe that complaint is already untimely.
Yeah, but if Google, like somebody does a terrorist act, the first thing they're going to do is look at what was in his social media stream for 48 hours before that, and or who were his sources, and if they were correlated with the sources of other terrorist acts, that would be a clue.
Now that allows the investigation after the fact, but it doesn't help stop something. Now, it's interesting, how many people think that you should not be able to buy a copy of Mein Kampf or to find it online? Okay, I'm not an expert in European law, but I think it's illegal in most of Europe, in much of Europe.
Definitely in the UK.
Okay? Illegal. So if you want to study the mind of a fascist, how do you get access to Hitler's own writings? It's a phenomenally complex problem. And terrorism is afflicted, of course, by the fact that everything about terrorism is hot button. But you also find in this day and age, I think, you gave a great articulation of it, but one person's terrorist is sometimes another person's freedom fighter.
Yeah.
Okay, and the difficulty is when you're dealing with global platforms, and I think there is a huge virtue of having global platforms that allow people all over the world to connect and to interact and to share and compare experiences and perspectives. What happens when one regime defines as terror what another jurisdiction defines as freedom fighting? And the difficulty is, if you're trying to use legal standards, then you're in extraordinary peril. And you also do run up against First Amendment limitations. Because are you going to forbid reporting? Are you going to forbid a news outlet from using the name of a mass murderer Is that a matter of law? The same thing is true with hate speech. Are you going to move hate speech into dark corners where people don't know what the hate speech is that's out there? I mean, let me take something that's different. I'm not calling it hate speech. But there are a lot of people who think that Donald Trump should not be tweeting. How many people agree with that? How many people love the fact that Donald Trump is tweeting?
Until he starts a nuclear war.
Until he's, well, that's a different button, okay?
It might be the same button for Trump, unfortunately. That's the problem.
Yeah, but my view is, isn't it wonderful that we know the unedited, raw thoughts of this fellow? Yeah, it's great, okay? He doesn't have everybody manipulating it into something palatable. We get to see it. Well, you know, I've heard calls that Twitter should delete his account because his account is a hate speech account. Where are you going to go with that? How about fake news? Okay? Yeah, actually, like I'm pretty moderate. There's an argument that CNN is absolutely fake news because 23 hours of the day it's opinion. 1 hour of the day it's news. So maybe it should be called Cable Opinion Network instead of Cable News Network. Okay, I mean, look, I'm middle of the road on this. So I don't,
C-O-N?
Yeah, C-O-N. You know, I know somebody who tweets a lot would love that acronym. But you know, the issue of fake news reminds me as a kid. I might be tussling with somebody over a shirt that I wanted, and the other person wanted the shirt, and we both pull on it so hard that it tore, and each of us accuses the other person of tearing it. And to a certain extent, this is part of the public debate right now. I personally think that fake news is a very, very carefully constructed term. I think it's carefully constructed by Trump. I'm sort of putting my politics on the line here. But I think it's what we call lies. Or it might be errors, okay, because reporters make errors. But by calling it fake news and not just lies or errors, it's suggesting that this is something about the news media itself and is meant to undermine confidence in the institution of reporting and editing, which are news functions. So I think there's something there. And fake news embraces Macedonian websites. It embraces sites that purport to provide reporting, but they're just echo chambers for other sources and the like. It's an unmanageable term. What is the way to address these? Do you address these issues through regulation, through law? I'm very, very reluctant to go there because I think that as soon as you do that, you start getting into very, very active debates that touch upon strong First Amendment interests. On the other hand, I see nothing wrong with platforms or technology providers, what have you, making a decision about what they do and do not want to permit on their service. And then it becomes a question of what values do they want and what experiences do they want associated with a brand, with their brand. So, you know, some restaurants want a dress code, and they'll kick you out if you don't have the dress code, because they have chosen to establish an ambiance that they want for the restaurant. And if an online platform says, we don't want people to raise the temperature in this platform, they get kicked out. I was troubled by it, but how many of you are on Nextdoor? Okay. So I'm a member of a Nextdoor community where the local moderators are absolutely deleting every post that touches on national politics. Can't do it because they don't want discussions of national politics. People will get riled up. we want discussions about the craft fair or the farmer's market or maybe the county council or what happened at the board of trustees at Kenyatta College. But if you want to discuss something about the Republican Party or the Democratic Party or Clinton or Trump or whatever, boom. Well, that's a branding choice. And people can choose that that's their platform or not their platform based on that. I want to move along because I want to leave some time later on. One thing that's interesting about all of these issues, including piracy, which I would describe as either copyright or trademark infringement, or also fraud, is that if you're going to have moderators trying to do something about the public behavior on the platforms, what combination of three factors come into play? What is the competence of the moderator? How does somebody know when something is fake news? How does somebody determine if something is hate speech? Is it all in the eye of the beholder? And I have this problem when it comes to copyright infringement. Viacom sued YouTube for copyright infringement because YouTube supposedly tolerated the uploading of obviously infringing content to YouTube. And why was it obviously infringing? Well, because it had high production values and it was like a clip from maybe the Colbert Report or something like that. So how many people think that would be obviously infringing on YouTube? Raise your hands. Is it obviously infringing if Viacom uploaded it? No. How about if I told you that I have a business model? I'm going to take the most popular play discussed in American politics in the last 2 weeks, and I'm going to print up 100,000 copies of it without the authorization of the playwright, and I'm going to sell those copies for a profit on eBay. How many of you think that that would be infringing? What if I told you that the play was Julius Caesar by William Shakespeare? Still obviously infringing? Okay. So to know whether something is obviously infringing, you need to know a lot. And guess what? It might be infringing if that text of Julius Caesar had been edited by the chair of the English department at the University of Virginia and had restored certain lines in certain way, da-da-da-da-da. Maybe then it would be infringing of that scholar's work. These questions are so much harder than anybody wants to believe, even in copyright infringement, things that are supposed to be obviously infringing. If somebody were to ask me, is this YouTube video infringing? You're a lawyer, go to it. My budget would be maybe $25,000 to $50,000 to give a legal opinion on that, because I would have to investigate so many things before I could issue that ruling. So the question is, even on something that seems as though it ought to be clear, like copyright infringement, it's not. How about fraud? I mean, how many of you listen to news radio in the morning driving? And what percentage of those ads on radio do you think are just frauds? Okay? I mean, a lot of them. I heard one today about like guaranteed 12% you'll never lose your money, da-da-da-da-da. I go, raises a whole bunch of alarm bells. But we don't talk about whether that news radio station should be culling through the ads that are on it and saying, this is too good to be true. Let us now have a division that's going to investigate it. To its credit, I mean, television networks do have advertising standards, and they do have standards bureaus that do some checking on television. But is that an obligation we want to impose on platforms? One of the interesting buzzwords right now is over algorithm transparency. Why do things get elevated or suppressed in search results, in feeds, the like? And the fact is, I mean, the algorithms are pretty opaque, and they're sort of a mystery. And it's true that I will get different search results from somebody else. Somebody tried to prove recently that Google should be ashamed for certain autofill search requests that came up when they started typing the search requests. Well, I guess it turned out that the suggestions that Google generated were based on that person's own earlier searches, and that the display was saying more about the person doing the reporting than about Google. And there's a sense, and I've heard this more in Europe than in the United States, that these companies need to be explicit and transparent about how they rank things. Well, I don't know about you, but I think that the search engine optimization world is an arms race. It's an arms race between those companies that take money to game the search system and the search providers who are trying to ungame the game. And it seems to me that if you require algorithmic transparency, you have just delivered the keys to the kingdom to the people who are trying to corrupt the search results for their own purposes. Algorithmic responsibility is sort of a variant on that. And it seems to me that that enters into an interesting question of free expression. I know that Google years ago, it wasn't a case I handled, I think it was by Search King. Somebody got sued, somebody sued Google for defamation for suppressing a company in the search results. And they said, well, you are defaming me by making my web page seem less important than it should be on Google. And of course, part of the problem is that I think that company had been gaming the algorithm and trying to boost itself, and Google found out about that and knocked it back down. But the decision that came out in that case was, no, Google is not liable because its rankings are actually opinion, and that Google had the right to express its opinion in that way. But this is a major area of controversy right now. Another huge area of controversy is over whether an online platform must be proactive in eliminating unsavory or improper material, or should be acting, if at all, only in response to claims. And this became most famous because of the defense to remedies that exists in copyright law, in the Digital Millennium Copyright Act, the safe harbor, that says somebody is not liable for damages or broad injunctions if they meet 8 different conditions. And among the conditions are designating an agent to receive notifications of claimed infringement, and responding expeditiously to disable access to or to remove material that is claimed to be infringing. Now, those are conditions of a safe harbor against damages and an injunction. They are not, in fact, active obligations of a platform. They are conditions for getting a special protection. And there's rampant confusion out there in the world because many people have come to equate the safe harbor conditions of the Digital Millennium Copyright Act with the standards of copyright law and copyright infringement. And the argument comes out, oh, well, you failed to do something to qualify for the safe harbor, therefore you are liable. And the answer is no, that means we just didn't get a safe harbor. You still have to prove that we are responsible for other reasons. But on this, the DMCA envisioned that a copyright holder would notify the online service that something was infringing, and then the online service, to qualify for the safe harbor, could take it down off the service. But the person who posted it could then file a counter notification and have it put back up unless the copyright holder showed that it had sued the poster, in which case it would stay down. So it envisioned a sort of a three-party system of the complainant, the online service provider, and the person I'll call the respondent or the poster. And it would, the online service provider was just an intermediary on these notices and counter notifications. But then if it came to a head with an active dispute, the service provider wasn't adjudicating the dispute, it would be adjudicated by a court. That's the way it was envisioned. A lot of complainants say that this system is rigged against them, that nobody envisioned how many millions and millions and millions of notices they would have to send. And they complain that it is too much of a burden for them to have to play whack-a-mole. And there's a lot of reason to have sympathy for that, because it is a very laborious process to do this right. So the argument has arisen, we need to have take down, stay down. That when a service provider gets a notice and takes something down, it then needs to stay down forever. And it can't come back up. Not just if the user files a counter notification, but that they shouldn't have to go through the same drill for millions of other instances of the same work that may have been involved. Of course, as we saw earlier in my discussion about Viacom's uploads and Caesar, infringements aren't evident just by the nature of the material. You have to know who's done the uploading and if there's a relationship and what the circumstances are and the like. So the debate now is, no, you must keep something down. You must filter your service to ensure that things do not come back up. And it's a very active debate in Europe in particular right now, and there's a move, very strong move towards filtering there, but it's also happening here in the debates in the Copyright Office. But one of the important differences between a filtering regime and a takedown regime is this. The takedown regime under the Digital Millennium Copyright Act allows users to step up and say, no, I'm standing up for what I did. I want it back up. And then it either goes back up if the service provider wants, or there's a court fight over it. With filtering, the interest of that user disappears. It becomes just between the claimant and the service provider. And there's no way to respect the interests of the users. And one thing that's very, very important is a lot of the debates over these issues get couched in the corridors of power as debates between the entertainment and information industries and the online services. And it's considered to be a two-party battle. And what is left out of a lot of these are the interests of individuals who don't get represented in those. And in my view, it's very, very important to have vehicles for individuals with their own interests that are getting caught up in the wars between the entertainment and information industries and the online industries to express their own interests here. Blacklists and kangaroo courts. I was talking with some of my colleagues earlier today. Do y'all know what kangaroo courts are? How many people aren't familiar with the term? Okay, well there's a critical mass. So I went to Wikipedia. A kangaroo court is a judicial tribunal or assembly that ignores recognized standards of law or justice, which carries little or no official standing in the territory in which it resides. It's basically a non-court, non-rule of law facility for making decisions, where it could be decided based on whim or the like. it's used to give what some people may perceive to be rough justice that in particulars may be no justice. So I mention this because many of you may recall SOPA and PIPA, the Stop Online Piracy Act, and the Protect IP Act. Those laws were going to require advertising networks to cease working with alleged infringers, or were going to require payment processors to stop doing it. It was going to sort of reverse the case that I won for MasterCard and Visa that said that they were not responsible for cutting off payments to merchants alleged to be infringers. Well, when SOPA and PIPA failed, an initiative that had started before that legislation was introduced in the Office of the Intellectual Property Enforcement Coordinator in D.C. in the White House was what had set in motion something that we have today that I call soft SOPA. And it is an sort of informal understanding that payment processors will stop processing payments for bad people, or that advertising networks will not provide advertising that can provide revenues for bad people. Now, I represent some companies that provide virtual private network services. They are important services. But according to, for example, the entertainment industry, they are corrupt businesses because they allow people to access Netflix in the US when they're traveling to Europe. Or they allow people to bypass geo-restrictions that interfere with an orderly licensing scheme for entertainment works on a jurisdiction-by-jurisdiction basis. And it also allows people who may be engaged in infringements or fraud or what have you to make it harder to figure out who they are. So I've had some payment processing companies come to my clients and say, we're going to stop processing your payments because you're in a bad industry. Because we've been told that virtual private networks are bad, and therefore we're going to stop that. Now, I've never had a client actually lose that process, but I've had to argue several times with the banks. No, let me explain to you exactly what my client is doing and why it's legal and the like. But this is now as a consequence of informal enforcement efforts by the Intellectual Property Enforcement Coordinator and other organs of government to put people at a disadvantage. And I don't know if it's related to this or not at all, but I've heard also, I tend to be opposite pornography companies. They're actually very vigorous plaintiffs against technology and the like. So my expertise in porn is usually from the other side. But I've heard that it's actually very difficult now for adult entertainment performers to have checking accounts. Because banks have said to them, oh, we don't like your line of business, and so we don't want you as our checking account customer. So we're in sort of a world where there are these blacklists and kangaroo courts where people have been decided to be bad people. I like to go back to my 60s growing up and say, there's a list of people who have cooties, and people just aren't supposed to let those people with cooties eat at the same lunch table. It's going back to middle school. And for me, this is a problem with the rule of law because we don't see actual legal standards and actual notices and opportunities to be heard, to be afforded. Now, there's a counter-argument that, hey, the good news is the enforcement is going this way, and we don't have a federal marshal showing up at the person's door. Well, I hear the argument, but it still troubles me that we have a regime here that is sort of outside the rule of law.
Do you ever find in proceedings that if you ask the lawyers for the plaintiffs, whether they themselves use VPNs to connect to their own networks that the answer is yes.
Oh, absolutely. And one of my colleagues here, who is a federal prosecutor, ironically, I said to my colleague, I said, oh, I'm representing this company and look what they've got going on. And he said, yeah, when I was a prosecutor investigating cases, I used that service all the time. That's the way it is. It goes to the question of who is competent up here for when you're talking about online. No, I didn't put up there. But it goes back up to sort of that's the form of moderation. Whom a bank or a credit card company chooses to work with is a form of moderation. What is its competence? It doesn't have competence to determine whether a VPN is a good or bad service. What should the mode of decision be? Now, I will say what's interesting is that the way the payment processors have implemented these actions is through what they call their brand protection activities. Because they say, we do not want our brand being associated with this type of business. Well, arguably, that is their right. The one constraint that comes in is there's something weird when they are doing it because the government has asked them to. It's also weird when they are doing it because the government has asked their entire industry to, which to me raises very, very serious governmental and antitrust questions. And we'll keep going down because I want to wrap it up and take more open questions if people want. Traditional legal concepts can apply to regulate a lot of these technologies and online platforms. We had the question earlier about self-driving cars and the like. There might be product liability if cars are designed, to run into pedestrians and they don't have a way to deal with it. But we see some very broad tort law, sort of plaintiff's personal injury type law concepts being applied here. And in negligence law, you can sue somebody for failing to fix a problem. You can sue the grocery store for failing to clean up the banana skin that was there for 40 minutes, and I slipped on it, cracked my head, I get to sue. Now, negligence law is part of the general common law that's evolved over ages. I don't think there's a specific statute that requires you to clean up your banana peel. In a lot of internet areas, particularly in intellectual property, there are very specific statutes. But the statutes tend to cover specific infringements, specific infringing acts. In copyright and trademark law, unlike patent, there are no statutes making one person responsible for another person. Okay? There are no statutes that would say a service provider is responsible for infringements by a user. But judges over the years have come up with some common law type rules that say, if you are a department store owner and you lease out a department to an independent company, but they're wearing your uniforms and they're in your building and they're selling on shelves on your floor and they're processing their money through your cash register, then if they're doing something wrong, you're going to be liable. Because they sort of look like your employees. And that maybe they aren't your employees, but we're sort of going to make you liable for that. That's sort of a common law judge-made rule. Or similarly, if I sell you a product that's got no purpose other than to engage in infringement, then you're going to be liable. Now, Smith & Wesson may not normally be liable, but if I'm a gun shop owner and somebody runs into the gun shop and says, quick, my mother-in-law is outside in the car. What's a good size Glock for taking out somebody about 5'6", 180 pounds? And you don't need to wrap it, just give it to me now. Loaded. Yeah, let me load it. Maybe that's pretty good knowledge that he's about to go do something with his mother-in-law. Okay? Maybe the gun owner would be liable for that. This has come into copyright law. It came into the law in Google, where the Court of Appeals out here said, well, if an online service gets actual knowledge of specific infringements and fails to take simple measures to stop or avoid further harm, then it may be liable as a contributory infringer. And it was sort of couching liability there on a failure to act when getting that kind of knowledge. A judge in Illinois in the Aimster service basically said, look, you can have a service that's got infringing and non-infringing uses, and that doesn't make you liable. Doesn't. There's a very important principle in copyright law that says if a product is capable of good and bad uses, we're not going to assume that you have knowledge of particular bad uses just because you know that statistically it can be used for bad uses or what have you. But in the Aimster case, the judge said, well, but if it's used mainly for infringing purposes, then we're going to say that the service provider has to show that there was no reasonably priced way to prevent the harm. So that's sort of a negligence concept that comes in here. So that's a mode of thought that is coming into regulation of technologies and online services. A couple last things, and these have to do a little bit more with sort of debates between Europe and the U.S. There's a lot of ferment going on in the European Union about regulation of online platforms. A lot of it centers around GAFA, which stands for Google, Apple, Facebook, and Amazon. And it's interesting, I spoke probably about 4 or 5 years ago at a place called the Royal Institute of International Affairs, or Chatham House in London. There was a big sort of antitrust and technology conference, and the premise of it was, what are we going to do about the new permanent monopolies? But I don't think it was GAFA then. It might have been GEFA then. I can't remember. It was like Google, eBay, Facebook, Amazon. And I said, well, you know, I've lived long enough now that I've lived through a whole bunch of permanent monopolies. I have lived through the permanent monopoly of AOL, CompuServe, and Prodigy. I have lived through the permanent monopoly of Lotus, Novell, WordPerfect, Microsoft. I've lived through the permanent monopoly of digital equipment, Hewlett-Packard, Compaq, Cray, whatever other ones. What we tend to see, I think, is competition in the online platform space coming, or not within a technology, but from new technologies. And one of the interesting antitrust questions is whether companies have acquired enough market power in these existing markets that they control new and other markets. And that's a big question. But what we see, what I've tended to hear a lot in European fora, is that these companies are the poster children for a variety of problems on the internet. And I understand their views. We actually represent all 4 of those companies, but I won't speak for them. But I represent a huge number of individual entrepreneurs and startup companies and emerging growth companies. And my fear is that there is a very, very strong hostility to these big 4. that leads to suggestions that rules need to be created to force them to do things differently because of the perceived magnitude of the harms that they can cause. The difficulty I'm seeing is how do you create rules for them that don't end up blocking entry by the small fry? Because the good news for them, the bad news for regulators, I think, or at least for the markets, is that they can probably handle any regulation that is thrown at them. They've got so much money, they've got so much talent. But when you establish regulations for them, what happens for other people? Do you end up saying, well, we've got a rule for 4 companies, but 5th company, you don't have to worry about it? Will Yelp be the next company to be included in that? Would TripAdvisor, would what have you? Are others going to be able to overcome any regulatory hurdles that get imposed on them? And one of my fears is that there's a real risk of unintended consequences on the small fry, whom we want to encourage to become the competitors to the GAFA. What we want is GAFA to become like 12 letters long, and then 14 letters long, and then we move into a new realm. Yes.
What kind of regulations are people suggesting for GAFA?
A variety of them. Some have to do with very legitimate privacy interests. Some have to do with one that affects primarily Google and Microsoft. I'm trying to think who else. There's one that comes down from a decision of the Court of Justice of the European Union on the right to be lost to Google searches. It's called the right to be forgotten, but it's not the right to be forgotten, it's the right to be de-indexed from the major searches. So the case that arose was a fellow in Spain, I can't remember the exact details, but I think he had gone bankrupt and not paid his taxes or something like that, and the government had reported him in a Spanish newspaper back when it happened. And Google has indexed the newspaper and made it available online. Well, the decision was, at his demand, Google has to take the bad news about him off on the grounds that it was no longer relevant. Okay? It didn't require that the newspaper take him off the newspaper website. It just required that Google not help people find the newspaper website. And look, I get the idea of relevance. We have that rule. We have a sort of a right to be forgotten, a right to be indexed in the United States. Does anybody know the context? Your credit reports. Okay? Stuff that's more than 7 years old, they can't use against you. If you had a bankruptcy more than 7 years ago, I think it's probably not held against you. So the concept is there. But the interesting question to me is that the touchstone is relevance. And the idea is that, well, there's certain things that are just so old, they're not relevant. Well, let me think. If I'm a 50-year-old guy and I'm sweet-talking a 23-year-old woman that I want to be my bride, and it turns out that I was married and had 4 kids 25 years ago that I've never told her about. And I've sort of told her I was single all my life, and she's been the first dream I've ever had. And who's to determine whether the report of my divorce 25 years ago is relevant or not? And it's relevant to whom? This, again, is a contextual determination. And what's interesting is that the way the decision has been implemented in the EU is the governments are not able to make these relevance determinations. So what do? They say, Google, you make the relevance determinations. And so Google has a whole apparatus going on to field requests by people that they be de-indexed from Google search. And if you're in Europe and you do some search results, and maybe even on the search results here, it will say down at the bottom, some results have been omitted because of requests under European law. And one of the tough questions here, it's a very, very thorny political question, is we all know that you can make an end run around all sorts of limitations. So Google says, okay, this rule applies to us in France, we're taking stuff out of Google.fr. But it'll be on Google.com. Well, guess what? People in France can find a way to get to Google.com. Or they can tunnel with a VPN into Google Brazil or whatever and get its stuff. And so one of the big debates right now is whether, in response to restrictions or enforcement in one country, a global online platform must conform all of its global activities to the requirements of the one jurisdiction. That's a huge debate right now.
Really?
Absolutely, absolutely. Yeah.
Who is arguing that?
I think France, among others.
A question, a comment on the GAF idea. Many of those cases that at least that I'm familiar with, are relative to standards, effectively APIs, that these large companies provide as interfaces to access important, to some people at least, services, and may or may not make those interfaces available to their competitors or others who might like to compete.
Right. I am not as sharp on the antitrust issues myself. I think those tend to be particular on market power, about open access and sort of sharing access to platforms. One of the, and I think it's different, but I know one of the big issues in Europe, where Google may be fined $9 billion, I think it's $9 billion, has to do with Google's alleged suppression of local search results of services like Yelp compared to its own its own Google reviews, what have you. Question over here.
One question, just a reminder on time.
Yeah. So I'm just about through. One of the interesting questions, this may be blocked, in the regulatory world, is that there is a sense that there are two different things going on in debates between EU and the U.S. There is absolutely no doubt that European jurisdictions have a different set of, that's the wrong way to put it. Their priorities are a little bit different in weighing freedom of expression versus privacy interests. And we tend to emphasize far more broad rights of freedom of expression and freedom of access to information. And freedom of access to information is exactly what the Packingham versus North Carolina case was about, as the Supreme Court decided today. It's a very, very high virtue for us. On the other hand, we tend to have fairly weak privacy interests here. And at the federal and state levels, they tend to be a patchwork of privacy interests rather than one broad privacy interest. So there's health privacy, there's educational privacy, things like that. Europe considers privacy, I believe, an equal fundamental right to freedom of expression, whereas we tend to give freedom of expression a heavier emphasis. And that's a fair debate. That's an absolutely fair debate. Because to a certain extent, I tend to be a freedom of expression near absolutist. But if I can't have privacy, I may not be, as a practical matter, as free to say some things as I would like. And this is a very, very, very tough set of values to reconcile and to harmonize. and I don't have a good solution for it. One concern is that it may align also with a sense that on some people's parts there, that the sort of the dominance of U.S. enterprises globally on the internet is itself a problem. And there is some thinking that at least some people are happy to say, well, whatever it takes to bring U.S. enterprises down a notch. And so there's a little bit of geographical jurisdictional conflict there, but that is not at all to diminish the very, very real and legitimate concern about privacy interests there. And I think that particularly with the political developments that we've seen in the United States and in Europe, I think that the United States is at the moment losing credibility in many ways because of what's just happening here politically. And I think it becomes harder for us to do a good job articulating why we've made the weighing the way we've made the weighing. Anyway, so let me just open it up for any other questions that people may have. I've gone well through my time, and there's food and drink in the back. So I will take questions and I'll keep answering them. But if some of you want to go grab things while you listen to other questions and answers, please feel free to. But you've got a question up here.
You said something about how opinion for copyright would cost $50,000, take so much time. Could you see artificial intelligence changing that drastically, where it's maybe less of your time and obviously then less money?
No. Because artificial intelligence is going to boil down to algorithms, and algorithms are going to give rough justice, and it requires a focused, nuanced approach, where particularly in the doctrine of fair use, the courts, U.S. courts, have said in fair use that every case must be decided on its own merits. When that's the case, artificial intelligence doesn't work very well because it depends on pattern recognition, and it becomes very, very difficult to bring into bear. Now, artificial intelligence has been used on automating the sending of notifications of claimed infringement, but that runs into a problem that the courts have said that before somebody sends a notice, they have to take into account the possibility of fair use. And so those who want to send a lot of notices are themselves trying to create algorithms to figure out, well, what can we weed out? You know, if it's 15 seconds or less, or if it's this, that, or the other. So they've got that, but at the end of the day, they are responsible when they send a notice for asserting that something is an infringement. And they can be held liable in damages for sending a notice that is materially false. Now, as a practical matter right now, it's a little hard to hold people actually liable in damages. The Supreme Court today denied review of a case involving that, but the Ninth Circuit itself had a decision that made it clear that before sending a notice, you have to take fair use into account. Other questions?
Yeah, you said at the start you didn't really see the view so much of people that think regulation's not so relevant because they're like an entrepreneur really in love with the internet or whatever. And I kind of have that view, actually. Almost everything that you talked about related to businesses and companies. But I feel like Facebook's not the internet, or Google's not the internet. The internet's just a decentralized routing system.
Right.
And so I feel like when regulations come along that are targeted at businesses, as they generally are as far as like say copyright infringement, like the DAT copying, it doesn't really work. Like people still make copies of audio files even though they made DAT tape copying illegal.
Right.
Or they shut down Napster, but now we have BitTorrent, which is decentralized. You can't shut the
Right.
BitTorrent company down.
Well,
Like-
so go ahead.
So I was just wondering, like, what do you see as regulation versus the decentralized capabilities of the internet? Because I know, Facebook doesn't have to be
Right.
the only mechanism for speech online, or Twitter.
You can have decentralized enforcement, and then that creates its own blowback. So the recording industry started suing downloaders, sued thousands of downloaders, and provoked a reaction. It sued one single mother in Minnesota and got a $1.5 million verdict for the fact that she downloaded 24 songs.
But it didn't stop downloading songs.
It didn't, but it may have made a dent in it. It was funny, back around 1999, after I had won the Rio MP3 player case, I was at a panel at Harvard Law School with the head litigator from the recording industry. And he was just blasting all this technology and everything. And at the time I said, look, here we are at Harvard Law School. You want to know the easiest, fastest way to stop illegal downloading at Harvard Law School? Find 20 members of Harvard Law Review who are downloading songs and sue the hell out of them. And which was screwed up their chances for all their Supreme Court clerkships and everything. And yeah, you could have some impact litigation. Now, one of the problems with copyright law is that it has lost its mind because of statutory damages. The fact that somebody could face a jury verdict of $1.5 million for downloading 24 songs is ridiculous. Now, the recording industry knew it was ridiculous, so on appeal, they merely cut back and said, oh, well, we'll accept $222,000 instead. Okay?
Right, but, while regulation has gotten more ridiculous for copyright, so has the rate of copying and infringement over time. More people copy stuff than they did 10 years ago.
Well, I don't know. I think a lot of people were copying a lot of stuff 10 years ago. And I got to tell you,
Worldwide? Worldwide?
Well, that maybe not worldwide. Yeah, and I'm not sure I even agree worldwide, because one of the beauties is that the rate of Pirate Bay use in Sweden reportedly fell dramatically after Spotify started. Okay? There are now many acceptable alternatives to illegal copying. And one of the arguments all along has been that there is a supply problem that leads to infringements, not just a demand problem. And it's funny, this is recorded. I have a dear friend who went to France for a school exchange and was learned about a recording artist in France, and bought 2 CDs and came back to the States. And they would not work on her computer because of some kind of restrictions. She said, I've paid for these CDs, not working. All right, I'll just buy them all over again on iTunes. She goes to iTunes. Sorry, not available in your country. Available only in France. Well, where'd she go? LimeWire. Well, I wouldn't have charged her $50,000, but I would have given her opinion. That's not an infringement. Okay, you are just trying to get the music you thought you bought in a jurisdiction where it is not available. Okay, that's a problem. Now, the recording industry would have treated that as too scurrilous, criminal downloads. I don't know. I think it is wise. Look, we've got to have some common sense. We know stuff goes on. But I think it is also the case that I've seen many, many people make hasty assumptions that something is wrong even when it isn't wrong. And the fact is, a lot of these issues are much more subtle and nuanced than people believe. I don't know if you know it, but by the way, if you make a reproduction of 1,000 songs onto CDs that you buy at Best Buy, and make 20 copies of those songs and give them to all your friends as holiday presents, that may be entirely legal. Now, I'm not encouraging you to go do it. But it turns out that there's a little known law. If those CDs are music CDs, I mean CDRs and CDRWs, but with the word music on them, not data CDs. They cost a few pennies more. There is an absolute immunity from a copyright infringement lawsuit in Section 1008 of the Copyright Act for the non-commercial use of a consumer, by a consumer, for making reproductions on those CDs for non-commercial purposes. So you don't want to get into a barter thing. But there is a immunity in the law. Nobody knows about it. You actually pay a couple pennies more for each CD. The money goes to the Copyright Office, and they send it to Britney Spears and others. But I mean, there are all sorts of nooks and crannies and subtleties in copyright law that you sometimes have to be humble on both sides of the divide about what you think. Yes?
Two questions quickly. If that's the case, then what makes it so that iTunes can distribute a CD ripper and advocate you ripping CDs into your iTunes to use on your... The second question is, any thoughts on blockchain and copyright protection and copyright at all?
Yeah, I really don't have thoughts on blockchain because I'm still too ignorant, and I've always learned to hold off when I'm not sufficiently knowledgeable. Apple may be protected by an interesting statement by the lawyer for the motion picture industry, speaking for the combined motion picture and recording industry before the Supreme Court in the Grokster oral argument. Because, as some of you may know, in the Grokster case, the Supreme Court struggled because the Grokster defendants, and that was Music City, Kazaa, and Grokster, were held not to be liable in the trial court and in the Court of Appeals based on traditional rules of copyright infringement law. And it went up to the Supreme Court, and the recording industry and motion picture industry said to the Supreme Court, look, whatever is going on, you've got to find a way to make this illegal. We just can't, it is intolerable for this to be legal. And we want you to change one of the rules that says, even if it's capable of non-infringing uses, they're still going to be liable. The Supreme Court didn't want to do that. They said, our alternative is, we want you to make people liable if they intend to cause infringement, and da-da-da-da-da. And one of the justices was very concerned about the effect of that ruling on iPods. And he says, but what about people copying their CDs to iPods? And the guy said, my clients, this is maybe not an exact quote, but it is close. My clients have said this, and they've said it for some time. It is perfectly legal to copy a song from that you bought onto your iPod. Okay? Perfectly legal. And what's interesting is, I think after the fact, after the Grokster decision came out, they said, well, we didn't really say that. We didn't really mean that. I mean, what do you mean? It's right there in the oral argument at the Supreme Court. It's like, no, well, what we meant is, the reason it's perfectly legal is that we consent to it. Well, that's not how it came across the Supreme Court. But the bottom line is, I think that statement has sort of protected Apple. Plus, and I don't know the facts of Apple. We represent Apple, but I do not speak for Apple, and I'm not privy to stuff inside. Apple has, I'm sure, a lot of contractual relationships with major music sources, So who knows what's in the contracts?
Thank you for such a nuanced presentation. I was wondering how the government is asking companies in the industry to filter content.
Well, I don't think, well, I don't know actually, because I don't know what's going on behind the scenes. I think that what's happening is that it is largely an embarrassment and a PR factor rather than a direct regulatory approach. Perhaps the payment processors with WikiLeaks was sort of a do this or else. But in terms of the fact that some notorious sites get taken down or accounts get taken down may reflect just a wide variety of considerations. It's hard to tell because they absolutely do have the right. I mean, if Twitter doesn't want me as a user, I don't have a right to be on Twitter. And if it decides that I've used terminology that it disapproves of, I don't know whether it would kick me off or not, but it would have the right to, because I don't have some fundamental right to have access to Twitter or right against Twitter. I have a right to keep the government from keeping me off Twitter. That's what the decision today was about.
Yeah, I have a question. It's a big issue. It's total information awareness. Okay, that was
Poindexter, right?
Was, I don't know, 5 or 10 years ago, and it was kind of hushed
Yeah.
down. But today, it's playing big time. Okay, with Cambridge Analytica and all the psychological profiles. You know, the big the GAFA basically has all this information, and there's some way that it's being leveraged out of them, as well as now the ISPs, and they're making money. So I really have a concern, not only for myself, my family, and other friends, is what does an individual have access to knowing what their background is? It's being sold, and yet what right do I have, and how do I get access to review what my background is?
Great question, but I want to separate it into two parts. Because one is, what about the fact that they're making money?
Yeah.
And the other is, how do I become aware? Okay? I think let's start with credit reports. I think there are federal laws and regulations that entitle you to know what's in your credit report.
Yeah.
Now, they may be able to sell you your credit report. They may be able to make money off it, and certainly they try to make a lot of money off it. But there's a law there. Short of law, it becomes, again, a branding issue. You know, I'm not sure that a worker at a Ford Motor plant is entitled to review the worker's personnel file. Okay? Not sure there's a right there. I don't know that I have a right to all my medical files. I might not. Whether somebody chooses to make one's usage history, or whether a service chooses to make one's user history available or not, may be a branding issue. It may be a revenue opportunity. Who knows? But to me, that boils down ultimately to what are your incentives for using this service? If the terms by which you use it are acceptable to you, you're going to use it. If they aren't, you aren't. We are in a world of mass products and mass services. So no, you can't go and individually negotiate, although services may allow you all sorts of individual options on pull-down menus. But you can't exactly, call up and say, I want to speak to the CEO and do a special deal. It's just not going to happen. But again, I think that boils down to, on balance, how do you appraise the trade-offs? Safeway. Look, do I like the fact that Safeway knows, what brand of toothpaste I buy? Well, that's not a big deal, but I've saved 25 cents on that toothpaste tube by letting Safeway know what toothpaste I buy. And when it gets to be, which brand of condom or a bunch of yeast infection products this week or something like that, that starts getting a little more personal. But that's part of the market.
I was trying to go beyond the marketing. I accept the marketing, but now it's profiling people. Okay, I went to the Computer History Museum, and there was this professor that was involved in the original research for Cambridge Analytica.
Right.
And he says he's actively being paid now by Facebook, where they're starting to understand using machine learning just on your face profile. Okay.
Right.
There's incredible technology that's being discovered of profiling you just based off your face. Okay. What your hormone levels are, what your likely religions are, what your speech is, what health effects that you have, okay, where you could be redlined in getting insurance, okay, that you have symptoms of being, heart patient,
right,
diabetic, or it's really, really getting into a very sophisticated science.
It is, and I don't mean to diminish the hard questions, because I share with you the sort of the ick factor there. But this then goes right into the question of the trade-off between privacy and access to information. Okay, this is not my argument, but I'm just positing the argument. Every one of those things you've just said would give the insurance company more information that might allow it to have a truer view of your health than you have disclosed in your application. I think progressive insurance requires, some of its policyholders to have a dongle of some sort in the car that will basically tell them how fast you drive. And if you want their rates,
you get a discount.
Yeah, you get a discount, okay? And guess what? Sorry?
Alternatively, you're paying higher.
That's right. And this ends up being the subject of broader policy debates, which would start at the most ungranular level of, are we going to allow insurance companies to charge men and women different rates?
But then there's this political thing. They're saying that they can understand what your hot buttons are, okay? And they feed you your news and everything in this bubble. And so they can persuade you to vote or not, or how to vote. And so now it's becoming a tremendous power for Google and Facebook or whatever, that they could be the next president, because they understand the feelings of the nation, of the world.
Right.
And they know how to manipulate that.
So, in other words, it's Gallup poll on steroids.
Yes.
And so now the question is, well, should Gallup poll be asking me my income when I answer my questions about presidential preferences? The question becomes, how granular do you want things to get? And look, I'm giving an explanation. I'm pretty agnostic on these issues because they're big, hard issues. My concern is that anytime we think we have the easy solution, we have probably missed the 87 unintended consequences of that solution. I mean, the fact is, don't we want politicians who know what my hot buttons are? Okay? It's like, okay, damn it, yeah, I mean it on this. You know, is there some algorithm that says, yeah, if it takes me 8 seconds to click like, that's different from if it takes me a nanosecond to click like? There's some weird, I was reading this, there's a criminal law decision, there's some weird test to determine whether somebody is a pederast, supposedly, depending on how quickly they click the mouse when seeing pictures of scantily clad kids versus scantily clad adults. And it was rejected by the court as not scientifically valid or whatever. But they were purporting to say, you know, yeah, if there's a 40-year-old in a bikini and it takes you half a second, and an 8-year-old in a bikini and it takes you a tenth of a second, then you're sweet on the young ones, is the argument. There are all sorts of ways that people are trying to get information. And at one level, getting at the information is getting at the truth. Now, there are two problems. One is either they've gotten too close to the truth for comfort, because we want a zone of privacy around us. And we want something, just don't come, you know, look, you can come onto my property, but you can't crawl in my bedroom window, thank you very much, okay? But on the other hand, what we don't want is algorithms saying, oh, I'm African American, therefore you assume I'm voting Democrat? Are you taking me for granted? I mean, that's the problem on the other side. And the bottom line, I think with Facebook and Google, again, I don't speak for any of these companies, is a lot of what they want to do is that they are looking to match you with somebody that wants to sell you something or persuade you something, and they know that you are a good prospect because of this. And, you know, I wish they would do a better job. I buy a suitcase online, and then for 6 weeks, I get advertisements for the suitcase I just bought. I wanted to figure out that I've already bought it. Thank you very much. I'm now moving to booking my flight. Okay? They haven't learned that yet. To a certain extent, I want them to know me better, up to the point there's that ick factor. Again, please don't think I'm particularly on one side or the other of this divide.
There's lots of ick factors. I mean, I think, you know, when an adult is at an age and is now being held with a higher level of responsibility, but a young child, a teenager, okay, that is now developing a profile, okay, right, that could be devastating for his, you know, getting into college, getting into certain careers, certain
right,
occupations.
And that's a really good point. But here again is an interesting question. Does the fault lie with those who create and use the algorithm? Let's say the child, the young person who does something shouldn't have done. Now there's a record of it out there or whatever. Does the fault lie with people who've created or used the algorithm, or does the fault lie with those of us grown-ups in our society who've turned our society into a vindictive and unforgiving place? There has been a hope in the past that when the fact that everybody has skeletons in their closet would come out, that maybe everybody's skeletons would be less dramatically disqualifying from X, Y, and Z. And maybe we need to go and some faiths are explicit about this. They're very easy to forget and forgive, not to forget, but they're very easy to forgive things. But one problem right now is that we are right now, particularly in our political culture, but also it comes out of our social culture, we are an ammunition gathering society because we're planning to use that ammunition for something someday.
Yeah.
And that's a social phenomenon that is, I think, at the heart of it. And that, to me, goes to the right to be forgotten issues. it seems to me that, if I were married and divorced with 4 kids 25 years ago, I shouldn't have a right to keep people from learning that. Now, maybe if I'm going to have any right at all, I should have a right to put my note in the file, to say, let me explain to you why I got divorced. Not that we really want people to go down that path. But the point is, you have a moderate opportunity to correct your credit report by having your statement in it. And maybe that's where we go. The difficulty is our ammunition gathering society is a reactive society. And it is getting stimulated by the format of our inputs and of the speed with which we digest and respond to our inputs. And, in everything I've been trying to argue, I'm arguing for considering the implications, considering the nuances, considering the subtleties in a world where, a 1-second transaction allows no subtlety or nuance. But that's a broader societal issue. It's why I'm so keen on newspapers, on paper. I would rather read only 8 articles per day and read 15 paragraph articles and get to the 15th paragraph. It would be better for me than reading 80 tweets per day, or maybe getting 2 paragraphs in. And this is a huge lift right now. This goes to fake news and defending against fake news. I think that we are responsible for fake news. How many of us have unwittingly propagated fake news? I know I have, and I try very hard not to, okay? And part of it is we need to slow down. I've been having a huge debate with a friend of mine who was a journalist, and we were journalists together in college. And he is like all in on Louise Mensch. How many of you don't start if you're not looking at the stuff now? She's sort of like a left-wing Russia conspiracy theorist Breitbart. And she comes up with all of these things, and she may be right some percent of the time, but I know that she's wrong enough of the time to be, in my view, entirely unreliable. But she keeps highlighting everything she publishes with exclusive. You saw it here first. And one was that Trump has already been impeached, or the vote on impeachment has already come out of the House Judiciary, and that he's under a secret indictment and this, that, and the other. And for her, it's always, I'm first with it. And my friend's saying, wow, she's so great because she's got this stuff first. And I'm going, I don't care what's first. I care what's accurate. But in journalism, look, any good journalist wants the scoop, which means the first. But part of the discipline and grown-up responsibility of being a journalist is saying, yeah, I think I'm pretty sure about this, but I've got 2 editors looking over my shoulder who are telling me, show me how many independent sources you've got, and we're not running it until you've got that. So speed is not the virtue in that context. There was a question back there I didn't want to, yes?
And then I think we really have to wrap up.
Well, actually behind you, but give it to him afterwards. You go ahead first.
We got a company, actually, there's a company called Linking Network for the Republican Party.
I think it's on, but hold it closer.
Yeah. Sorry. We actually helped the Republican to redistrict the voting system based on the social medias once. And then on those meetings, Facebook, Microsoft, everybody is a source of provider of information. So everybody in this game provides much information for people to figure this out.
For people, sorry, when your voice drops, it's hard to hear.
It's information, these activities of providing information just to redistrict the Republican area voting to get more seats. This game has been around for the last 6 years.
Well, this has been a problem of gerrymandering that has gone back for years. This just means there are more tools to predict. And then, so the question is, do we say that the problem is the tool, or do we say that the problem is the gerrymandering? I mean, I think it's important to be aware of how the tools are enhancing these, but again, I would rather put the emphasis on the behavior using the tools than on the tools, because those tools may end up having absolutely benign purposes. One of the things I loved about the Supreme Court's decision this morning in Packingham versus North Carolina is the Supreme Court acknowledged the importance of agnosticism about what is coming down the pike in the future, and that it is very, very important to keep things free for all the developments that may occur, not just to focus on today. So I hope that answers in part your question. Then let me go to the fellow behind you. Okay.
But one fact I want to share to people about privacy. One credit company based around here, one of the parameters they use for identify who you are is your shoe sizes. And then I was in an IoT panel and making fun. The lawyer wrote that pamphlet that I had to read all the time and say, isn't that biometric data? But never clearly defined it. They have like 4 paragraphs and never forget what it is. But they do know your shoe sizes.
But again,
that for me is my private data.
Well, not necessarily, because one of the pieces of evidence at crime scenes will be your shoe left an imprint in the dirt or in the mud. And in the O.J. Simpson case, his Bruno Magli shoes were featured on that. But actually, more than shoe size, apparently there are people who claim that you can identify people individually just by the way the body dynamics work when they walk down the street. That gait, walking gait, is a unique identifier. So, this will be the last question back
Early on, you mentioned the kangaroo court concept. I was wondering if you thought the FISA court, by definition, is a kangaroo court.
Actually, no. And it's a great question. I think that the FISA court I'm concerned about the secrecy of the FISA court, but I also understand that there are some court proceedings that need to be secret. The question is, how do we make it as little secret as possible? What I have seen from the FISA court, though, when it's come out, has caused me to be reasonably impressed with the sensitivity of the judges to some of these issues. I think that most judges, and actually jurors, when things get to jury trials, although they wouldn't have national security issues, they take an oath to do justice, and I think they are reasonably conscientious. My greater concern has to do with United States magistrate judges, who are sort of like assistant judges in the trial courts. They are not presidential appointments with life tenure, but they are appointed by the other judges in the court for 7-year terms, and they help the judges handle their workload. The magistrate judges are generally given the job of approving warrants, search warrants, and the like. And one thing that upset me greatly, we represented several companies and organizations supporting Apple against the FBI on the iPhone, and the request to hack the iPhone. And all of this happened, I've forgotten now exactly when, but it was 2 to 4 months after the murders in San Bernardino. The government had the phone. The phone wasn't leaving the country. The phone wasn't expiring. The government had it. Apple was not going to sneak out of the country. Okay? The killers were dead. This was now months after the event. And the government went and asked the magistrate one morning, give us this order. And the magistrate gave the government the order immediately, without waiting to hear from Apple, and entered an immediate injunction against Apple and said, oh, but by the way, if you don't like this, you can oppose it within 5 days. Now, there was a magistrate in Brooklyn on another iPhone case who said, okay, Apple, you have 5 days to respond. And this order does not go into effect until after the 5 days is over. But the judge in San Bernardino entered an immediate order, and the government was telling Apple, you are now in contempt of court for failing to give us that hack. And I'm going, the magistrate had no business entering an order without hearing from Apple. And in a lot of these environments, and I can't speak about that judge, I don't want to cast aspersions on that judge, other than incredible and improper haste in granting something without hearing the other side. Many magistrate judges have come out of U.S. attorneys' offices, and they share the same lunchrooms as U.S. attorneys' offices, maybe in the courthouses. And they are used to dealing with them day in, day out. And government attorneys are generally entitled to a great deal of respect because they do have high standards of integrity and the like. But the idea that a magistrate would say, oh, you asked for it, boom, you've got it, troubles me. And there's a lot of that where magistrates are signing warrants. The warrant that seized my guy's domain name was on extremely thin basis. And then the magistrate allowed all of those extensions to be in secret when there was no justifiable reason to hide the fact that the government actually didn't know. I thought it was secret because they were putting together a massive conspiracy case and they didn't want to tip some other people to what was going on over here. No. The secrecy was, well, oops, Your Honor, we seized this without knowing why we seized it. Okay? That magistrate should never have approved those secrecy. That, to me, is the bigger question, far more than the FISA court.
In the San Bernardino phone, apparently there was no useful information on it because we never heard anything. Would you?
Well, to me, no news is no news. I just don't know.
We have leaks of every other type. Why not this one?
How many requests have been denied by the FISA court?
I don't think we know. We might know, but I haven't tracked it. Okay. Yeah. Well, thank you. Gosh, y'all have stayed a long time. Thank you very much.